Joining me for the first time today, Roger Foley. Roger's in Florida, I understand. Roger, I'm looking at your CV and I see you and I have something in common. We, unlike our next guest, didn't have a basketball team in the finals of the NCAA, but we do root for Alabama Crimson Tide because Joe Namath, my former quarterback of the Jets, was on it, and so is yours. Welcome.
Welcome. How you doing?
Good. Okay, so now let's get to some work here today. This detective is going through, and she's on cross-examination by now, and what the defense attorney is trying to bring out is that there's a lot of stuff he extracted, he had, and let me just get this right, how many thousands, that doesn't matter, 33,000 pages, and his report is 7 pages, and so he's not giving the full story. But let me first go to you, Roger. Does that mean anything?
Not yet. They're not telling us what they're looking at. I mean, it's just information he's searching for, or she's searching for, and he's finding it. It's not really giving me anything yet other than he's not being detailed, and he already admitted to not reading through the report.
Roger, do you think the defense is going to say, hey, I gave my phone to the dad while the dad is like running over to, I'm hitchhiking, running to the hospital behind the ambulance? Or what do you think the explanation of that is going to be? Not that she has to explain. Remember, the state has to prove the case. But what do you think the explanation that will be hinted at is?
Well, obviously that the dad who was present at the scene, that maybe he was searching and he used her phone, or someone else that was present was searching that. Obviously, they're not going to want their client to take the stand and discuss that, as you said.
One of the questions I have also is I've seen cases, and I'm sure you have as a criminal defense attorney, where a parent or a caregiver or somebody doesn't bring a child to the hospital or a doctor for less and gets indicted. And here the father's saying he saw all these bruises and he didn't. So either two things happen. Either he saw them and he didn't because he didn't, or he saw them and didn't because he's negligent and he's not charged. What say you?
Correct. It's one or the other. I mean, either he did it or the babysitter did it, but either way, he chose not to report it. And it's important. I mean, obviously, if there was a bruise on her backside or bruises on her face and he doesn't take her to the hospital, that's just neglect. If he thought that the babysitter, did it, then common sense tells you as a parent, you'd be looking into that and talking to the child and obviously taking her to the doctor, as Gene said.
Roger, he's got me going now. Gene's got me going now. What are your thoughts about it?
It's not just modulation, but it's transitions, going from what you're going to be talking about so that jury knows what you're talking about. She's cross-examining you. You have to give some guidance to the people of the jury who don't do this every day for a living, and give some guidance where you're going, just like you're leading the person you're cross-examining. You need to let everyone know where you're going. There's not that many aha moments in our job, as we all know.
What Roger's talking about, ladies and gentlemen, is you have to have a theme that is conveyed to the juries. This is really crucial, and let me tell you why, in case it's not coming over to you, and then I will talk about it with Gene and Roger, is because Dad said he went out the night before to the police and to the social worker and to the hospital, and he bought milk. And then in the morning, he said he gave his daughter milk and cereal, and she was fine. The Lindsay Partin, who's on trial, said no, the child collapsed about a minute after getting to the daycare, after the father brought her in with a hoodie on her and left, and then I called 911. And the reason it's important is because if the subdural hematoma occurred in the morning with Lindsay, then obviously the child could have had milk and cereal. If it didn't, then she couldn't have. So, Roger. Okay, the cop was on the stand yesterday who investigated this, and he didn't have any answer for this except I wrote it down. Jason Wesley's story was not true, but not a lie. I think I've heard that before. In my case, Aaron Hernandez. But what's your take?
Obviously, it's almost he's sitting there realizing that he made a mistake. He really didn't do the investigation that he needed to do, because you have someone who now, a year later after the incident, is changing their story about their whereabouts. Was that child left alone? Was that child left with another party? Did the father, harm the child and her story is actually true? Or is there a combination of both? We don't know. And like Gene said before, it's the seeds of reasonable doubt.
And when you have something like that, Roger, when you have that, like, and of course, Jean's right. I mean, I'd be at the side counsel table, kind of like doing nothing. Sometimes you do see attorneys who just kind of, I'm going to disappear for a second. They disappear under the radar, and the jury's watching everybody. And the sad thing about this is a trial about somebody who died, Roger. So how do you rehab that?
Well, the prosecution's just going to stick to their focus and their theme, and they're not going to change it. And I don't know that they're going to. They can't explain it. So I think that I don't know, Gene. What do you think they're going to do? I don't think that they're going to. I don't know what they can do.
I love this. This is, can I just stop you? In the law, there's something called, and they have to change this name, but there's something called hot tubbing, where you sit your experts down and the people trying the case and you go over it together. This is kind of like it. Roger's in Florida asking Gene in Virginia, what do you do? I mean, is that happening, Gene, in the office?
Okay. All I can tell you is I've had witnesses that just were destroyed on cross. And you got to keep a poker face. And when you get up to do redirect, and you got to do redirect, you have to.
One of the things that was important on redirect, Roger, was, the history of this child is tragic. She was born to a drug-addicted mother, hence she was drug-addicted. The mother was on heroin, the child was born a heroin addict, had to be on method. She's had a tremendous, terrible beginning to her life, and she looks so happy in all these pictures. But can a child look happy? Especially when somebody, this brings me down, somebody admitted, like the person on trial, admitted to slapping her. Now, supposedly the detective that got that admission went to something called the Reed School. Now, the New Yorker did an expose a few years ago, and all defense attorneys know about that. That's like if I could curse, like a let's see, a donkey doo-doo. It's a donkey doo-doo type of technique anymore because it elicits false confessions. There's many people wrongfully convicted who were under the Reed technique. So how do you tell that to the jury, Roger? Exasperation is never good.
I'm going to walk them through that. I'm going to explain that, and I'm going to use witnesses to do that. I'm going to bring an expert on and talk about that technique and the problems with it and why it's not used anymore.
And yet there's people in our chat room, Roger, who love Jason, who thought he was perfect, that he kept his cool. He, despite the constant yum, and attacking as the boxing match that Gene had is dealing with, who said, though, he kept his cool and he was fine. So do you look at demeanor, or do you look at what they say, or does demeanor trump everything?
I think demeanor is a big thing, and I agree with Gene. He's just stone-faced, and it's difficult. I mean, he lost a child. He talks about a child that has marks and bruising. He doesn't do anything. He's talking about going with his friend and going to get milk and whatever. There's something off, and I don't know what it is, but as a juror, I think that they're going to notice that. They're going to say, you know what, this is leading somewhere. This father may have done this, and now this poor babysitter is getting blamed for it.
Wow.
Because of the use of her word.
It was pretty hot in that courtroom, and we've all been in courtrooms where it gets really hot, where you don't let the witness answer. But it had to do with putting her little Hannah, the morning that she ended up going to the hospital, in the back seat, or whether she fell in the back seat. Is that important in the scheme of things? Let me go to Roger first.
Well, it's important if there was another injury that could have caused the death of this child. So I think it's important. I think that the defense is trying to show that this father was reckless and that there were other issues, and it's not the babysitter. So I think it's important that the cross-examination she was just doing.
And Roger, indeed, when I went to look for all the records here and articles on people wrongfully convicted, even with the subdural hematoma, because it can be there for a while, and that's what's important, because there have been people that have been accused of it, like babysitters in the past, when it turns out another caregiver, like a parent or a sister or a brother, may have hit somebody in the head, or there may have been an accidental fall. That those cases exist, but how do you explain that to the jury? Because the jury just thinks as a defense attorney, you're just making it up.
Well, you have to talk about the traumatic brain injury, that an impact is what did it, and that an impact, the causes, when you have an impact to the head or to the face, there can be a delay in what you see. just like I've had years of boxing experience. If you get hit in the head, you may not notice the result the first day, the second day. It might happen a week later before those symptoms, where a family member will realize them and take that person to the hospital. So therefore, it's clear that it could have happened before, and the babysitter just didn't realize it.
Roger, I mean, one of the things that becomes important, though, is this Chris. Now, we talked about this. Let's tell our viewers what we were talking about as lawyers over the break. It's malpractice not to send your investigator out and go find Chris. It's not Lebanon like the country. It is Lebanon, Ohio. So it is in the United States to go find him. Because what if Chris says, hey, yes, he took me home. We were smoking dope, but he left his child home. That could leave an opportunity for her to get hurt. So it becomes crucial, right? I'm not saying that's what happened, but it's crucial.
Absolutely. I mean, the defense should be out there trying to find them. They can, retain an investigator and send someone out there to find this person. But I'm also sure that the prosecution is doing the same thing. I mean, ultimately, everyone's after the truth and what can better their case, either whether to help sustain a conviction or to get an acquittal. So it's very important what this gentleman has to say and whether he was even there.
Well, let's go back to this Chris then, Roger, and the suggestivity and all. I mean, everyone's watching this. We know about the serial. We know about the dating of the bruises. We know that this case is heading to the medical testimony about whether or not the subdural is old or new, or whether or not there was a hit on an old subdural that caused it to. I mean, there's all sorts of stuff that could be happening here in the future. But on this specific witness, do you think that if she gets knocked off from the prosecution's case, they try to replace her with somebody? We don't know what she's going to testify to. That's our problem, right?
Who are you talking about now?
Paula Smith.
Oh, if she gets knocked off. Yeah, I don't know. I don't know what she's bringing to the table. Something that jumped out to me, and I'm sure it probably jumped out to you guys, was the nugget that the father gave. And he said, I quote, "I knew about the timing since we were in the hospital." Meaning he was thinking about it. I was very surprised that the defense attorney didn't take that statement and use it right against them, because obviously he's already thinking that he is going to be a suspect in the crime, of the death of a child or the injury at that time of the child. And she didn't follow up on that, and that bothered me a little bit as a defense attorney.
Maybe very shy. Who knows?
Well, Roger, we try to treat all witnesses fairly, especially when they're fact witnesses that should have no axe to grind, that they're just telling the truth. So what have we done? How do we improve the court system so that witnesses are not scared to have their face shown then?
I don't know that there's anything that you can do in the system, if it's their right in that particular state. Some people are just private individuals, and they want to share the truth, whatever information that they can share. For the facts of the case, but they don't want they don't want the people commenting to them in the street and news reporters at their door. So I don't know if there's anything you can change for that. I think everyone's an individual, and I'm real curious what she has to say, because I think we may have an insight now of why she doesn't want to show her face based on what testimony she gives.
Yeah, that's an interesting thought. Okay, so we have a sidebar, and this gives me an opportunity, really, to bring in my two guests, Gene Rossi and Roger Foley from Florida. Gene's in Virginia. And one of the things we talked about, guys, before we went to this witness is that some people don't want to be shown. It's very clear that Paula Smith is really upset. You could hear her crying when she pointed out there, Lindsay in the courtroom, and it turns out that she said that her stepson, she had a wedding. They thought they were married at the time to Lindsay Partin. It turns out that they had a wedding, but they weren't married. What do you think of that testimony in and of itself, guys?
That's just odd information, right? I mean, she went to a wedding, but apparently either they didn't have a marriage license or whatever. There was no detailed information, so you don't know if it was a fraudulent marriage or they simply made a scrivener's error and the marriage license expired.
But one of the things, listening to the testimony of this witness, it sounds like, and it's gotten me, that she babysat other kids, and that from what I hear, Jason Weshy, the father, also two of the daughters, that from both of them, there doesn't seem to be any allegations of bad prior conduct. Now, you have to have a hearing to elicit that, don't you, Roger, in whatever state you're in, if you want to use it as a prosecution?
Yeah, I mean, if they're going to try to get into prior bad conduct, I mean, there's got to be a hearing on that, and the judge ultimately makes the decision. But oftentimes, unless it's very similar in nature, it's not coming in.
Okay, this is Paula Smith's testimony. I'd like to bring in Jean and Roger quickly before we go to a break. This prosecutor now has the same effect that the defense attorney did. She's frustrated with this witness who's not giving her the answers apparently. But what they wanted to apparently get to, two things. Number one, there was a toy train that was this woman cleaned up, and that Partin said when she came back to put it back where she found it. And two, that this witness didn't want to talk to the detectives. Now, any import? Roger.
I don't know. Obviously she's a little frustrated with the witness, and I always say prep, and I don't see that there's prep here, or the witness is just going off like a runaway train. I don't know, because we're not getting any information that I think is going to help anyone yet.
Who thinks of the word aneurysm, Roger Foley? I mean, I don't generally. If a kid, even when I was a prosecutor, that wouldn't be my first thing that I would think of. I would think of, impact, hitting, abuse. But aneurysm wouldn't be the first thing that came to my mind. How about you?
Yeah, it definitely wouldn't be mine either. I mean, you're talking about a 3-year-old. Unless he had reason to believe that she had been harmed or had head trauma to some extent, I don't know where aneurysm comes in. So I do think that it's a very good point that the defense is making. But I also agree with Jean. There are times where I think that the defense attorney is almost too hard on him and almost makes him sympathetic. So it's a delicate balance, and they need to be careful of that.
The prosecution geared into her and then focused on her, Roger. And as we know, once they focus on you, the law enforcement ain't going to let go. But one of the things defense is going to do tomorrow, because we understand now the state is going to rest tomorrow, there's going to be motions, is that we'll have the video of Dr. Werner Spitz, a forensic pathologist, as opposed to hospital people who don't see people usually who die from abuse and do autopsies, talk about the aging of the subdural team. Dr. Spitz has testified for me, as a friend of mine. Do you think that helps the defense in any way?
Well, I think it absolutely helps the defense, because it's going to talk about the time lapse between an injury and the ending result, in this case, death of a 3-year-old child. So I think it's very important if that's who the defense is going to put on, and that doctor, I'm assuming, it's a big assumption, but I'm assuming that he's going to talk about the delay and based on this injury and on the CT scan that the viewers are seeing.